service. And we are live. Welcome, everybody. It is Friday, March 1st, which you've all been waiting for because months ago, Judge Eileen Cannon announced that this was the day she was going to hear arguments about whether she should get rid of her trial deadline. And I know you marked it down on your calendars as like this is South Florida Argument Day, and it was. But then, boy wonder, Judge Scott McAfee threw a curveball and he said, not only is March 1st trial date showdown in South Florida, it is also the day I am hearing oral arguments on the question of Fani Willis's disqualification. And he did, and we were there for both. Now, how did we divide Anna Bauer in half and send half of her to South Florida and send half of her to Fulton County? Well, we didn't. We sent Anna to South Florida, and Roger and I put on our best Anna Bauer imitations. I wore a red wig, aka the guinea pig shirt. Roger put on his best Go Taylor's Boyfriend shirt. And we covered the Fulton County case as Anna Bauer. We weren't there in person, but we watched every minute of it. And Anna spent the whole day without her phone in court with Judge Eileen Cannon. And here's the thing. Roger and I actually know nothing about what happened in court today in Florida. And Anna knows only about Fulton County what she has been able to pick up since leaving court in Florida. And so what we're going to do is we're going to interview each other and thereby debrief on the two cases. We're basically going to have an editorial meeting in public, except that we're not going to discuss what we should do about it, but we're going to debrief on this, and we are going to do it live in front of you. All right, we do not have a live audience in the virtual jungle studio today. We only have the YouTube audience because we put this together really fast, almost as fast as I'm talking. But let's get into it. It's been quite a day. Anna Bauer, you got up early this morning to get in line for Judge Eileen Cannon's court in Fort Pierce, Florida. The key question that everybody wants to know, was Lawfare first in line?
Ben, I hate to admit it, but Lawfare has been dethroned. Yeah, I know, right? It's a huge disappointment. There are times when we have been like second in line, but we actually should have been first in line.
But this one we just got beat.
But this one this is the first one we've been beat fair and square, I think.
Although I just want to say, as Adam Kinzinger's cousin wrote to him, the first line of the letter, Anna, what a disappointment you are to your family and to God.
I know.
For being, what were you, fifth? Sixth
so I think that I ended up coming in sixth to get into the courtroom, although it was very confusing because there were multiple line lists. It was a whole thing. But I will say, in my defense, I usually am pretty good at figuring out when I need to get to court to be first in line. But my mistake this time around is that I had been so focused on Fulton County that I actually did not even realize that Trump was expected to show up in person this morning in Fort Pierce for his hearing with Judge Cannon.
I didn't know that either. Did others know that? Did you know that, Roger?
No, I did not know that either.
I did not know until I showed up, and who is in first in line other than Alan Foyer from the New York Times and Maggie Haberman from the New York Times and Eileen Sullivan from the New York Times. So they had the 1, 2, and 3 spot because I guess that they expected that he was going to be there. And then I can't remember who was in the other positions before me, but we were like ended up being about 6 to get into the courtroom, but did get into the courtroom. Trump was there. Jack Smith was there as well. So those two guys meet again, and it made for a lot of color in the courtroom.
Yeah. So what happened?
Yeah. So, well, in terms of the substance of
No.
Oh.
Fuck the substance for a minute.
Right.
Let's deal with the theater. We're in the
Okay.
first 5 minutes of this broadcast, and you just told me, which I didn't know, that Trump was in there with Jack Smith. Come on, give us the skinny. How was it?
Okay, well, it was a little bit because at this point, everyone's just kind of used to Donald Trump showing up for criminal proceedings. So it didn't feel quite as dramatic or as tense as it did during his arraignment or other proceedings that I've been to, the Court of Appeals immunity argument. Those proceedings felt a little bit more tense, but this one felt just it started to feel a little bit more normal that there was the former president and current Republican presidential frontrunner sitting at the defendant's table. There were, of course, he was also joined by his co-defendants in this case, Nada and De Olivier. They were both there as well with their counsel. So the defense table itself took up quite literally most of half of the courtroom, just because there were so many attorneys and so many defendants who were there. And it's a very small courtroom. So I was only a few feet away from Trump. And there were times when, reporters who were in the room would get really quiet so that we could, try to hear what he was talking with Todd Blanche about, who is the attorney that he kind of spoke with the most in a very animated fashion throughout the proceedings. The only thing I very clearly picked up on, and this is totally out of context, so folks, please realize that I don't know what they were actually talking about in this situation, but at one point, Todd Blanche whispered very loudly to Donald Trump, even if you did commit a crime, and then he kind of trailed off and got quieter. And so I don't know.
So you actually, wait, Anna Bauer actually today didn't just get into court. She invaded an attorney-client privilege conversation. Right? Or maybe the lawyer waived attorney-client privilege.
Exception, Ben.
Third-party exception, whispered too loudly. That's a hell of a scoop that you got did anybody report that before you just did?
I do not know. I do know that Catherine Falders from ABC was sitting next to me and she heard it as well, because we wanted to make sure that we all heard the same thing. So I have no idea if it's been reported, but you heard it here first.
You heard it here first, guys. Trump's lawyer acknowledges in court to his client in a stage whisper that he may have committed a crime, or he assumes arguendo that Trump committed a crime. All right. What else we got in the theater department?
One more thing that I will mention that was a really interesting moment in court. There weren't any, intense stares between the two, between Trump and Jack Smith that I saw. There were a few times that Jack Smith kind of looked over at Trump to see what his reaction was. But, and we'll maybe get into this a little bit more as to why this was raised when we get to the substance. But there was one point where
we're going to stay away from the substance as long as humanly possible.
Okay, well, there was one point where Judge Eileen Cannon asked one of the special counsel's office prosecutors when they would be prepared to make public their witness list. And I don't mean give their witness list to the defense counsel. Defense counsel already has a version of their witness list, which was ordered, as a part of Trump's bond conditions, the no contact list. I mean, she was asking, when are you going to be able to, have a public filing basically of your witness list? And I looked over at Jack Smith at that moment, and he raised his eyebrows like as high as they could go and seemed to be incredibly, bewildered and shocked by the suggestion that the government needed to be prepared at any point soon to publish their witness list. So, and again, kind of goes to the substance. So we'll get into that, but that was another kind of moment of color within the courtroom. And yeah.
So before we dive into substance, serious question. This was how many hours of hearing, and how engaged was Trump in it? What was his, what was he doing? Was he following the proceedings? Was he, I assume he wasn't texting, or like, what was his demeanor?
Yeah, he was engaged. He was a little bit more subdued than when I've seen him. When he's been in Judge Chutkan's courtroom, for example, there are moments that he's had that I've seen him be very animated and very kind of visibly, having a reaction to maybe things that the judge has said or things that opposing counsel has said. And he has seemed very, defiant or upset. But this time around in Judge Cannon's courtroom, he seemed a little bit more subdued, especially in the morning session. There was a morning and afternoon session, so it was a long day. After lunch, he was a little bit more animated. He, as I said, that's when, he was speaking with his counsel, Todd Blanche. Todd Blanche is always the one that he seems to be speaking with the most. He really didn't speak to his other. Chris Kise was also there. If you guys remember, Chris Kise is someone who was brought in originally to work on this case and was paid a lot of money by Trump. He was then kind of moved to a different legal defense in some civil suits in New York, and has been kind of relegated to being the local, counsel who can support the representation by Trump's other defense team, because of local rules that require you to have someone who's a member of the local bar there. So Chris Kise kind of fills that role, but he was there today, which was I haven't seen him in a bit in Trump, at least for the cases that we cover. And yeah, but Trump seemed to really just be having a lot of conversation with Todd Blanche. But he seemed otherwise pretty engaged, and he was there the whole day. I expected maybe he would leave at lunchtime, but he showed back up, and he stayed all the way until around 3:30 when we called it quits.
Pretty soon he'll be reading Lawfare. All right. So let's get into the substance. We're 12 minutes in. We should start talking about what happened today. What was on the agenda for Judge Cannon to consider, and what were the and what occupied time over the course of the day?
Right. So there were three main issues, and this was Judge Cannon originally scheduled this in November, I believe it was, as a scheduling conference to kind of, see what was happening with the deadlines for the trial date. So that was one of the main reasons that she was having this conference, was to address scheduling leading up to what was originally supposed to be a May trial date. But it's become very clear, as we've discussed in some of our Lawfare Lives previously, it's become very clear that the schedule was really off track. And so she asked the parties ahead of this scheduling conference to propose a new scheduling order and propose a new trial date. So that's the first issue. The second issue, it relates to Trump's motion to compel discovery that he filed several weeks ago. And the question there is whether she ought to hold an evidentiary hearing on the scope of the prosecution team. And Roger, jump in here if there's anything you want to say about this motion in particular. But basically, Trump's motion to compel discovery kind of implied that he was going to be making a selective or vindictive prosecution claim. He wanted to expand what is known as the prosecution team to not just include people who have worked on the case in the special counsel's office or in DOJ before it went to the special counsel or FBI agents. They wanted to expand it to include members of the intelligence community, for example, who the special counsel has consulted with regards to the classified documents, basically anyone that the special counsel who has communicated with, who's a part of the broader intelligence community or another federal agency or the White House. They wanted to include that within the scope of what they should get in discovery, basically. And so they made this big motion, gestured towards a selective prosecution or vindictive prosecution claim, and so Judge Cannon is trying to determine if she should hold an evidentiary hearing on expanding the scope of the prosecution team and, what exactly it is that the special counsel's office should have to hand over to Trump that they haven't already. And so that was a big, topic of discussion, although it seemed to be kind of like, should we hold this evidentiary hearing? We ended up kind of having a little bit of legal argument on the motion itself as it relates to what it means to have the scope of a prosecution team, and how the special counsel has defined that.
Okay, so I wanna ask a question, the answer to which I think is going to set a pattern for the rest of our conversation. Did we come to anything like a resolution of this question?
No. And we also, on the first one that I mentioned, which is the trial date, we also did not have a resolution on that either.
Right. So we argued about trial dates and we don't have a trial date, and we argued about whether we should have an evidentiary hearing on selective prosecution and expanding the prosecutorial team to include the entire federal government, and we don't have a resolution of that. What else did we argue about?
And then the third and final thing that was the topic of discussion that we also don't have a resolution on.
No, you're not supposed to announce that. You just let go all the dramatic tension. Okay. Let's try that again. Let's try that again, Anna. Okay. What else did we talk about?
The third and final topic of discussion related to the special counsel's motion for reconsideration. And that motion of reconsideration actually relates to the motion to compel that I just mentioned, the one that Trump kind of gestured to a selective prosecution claim and, made these kind of gestures toward claiming collusion amongst federal agencies and the special counsel's office. They appended to that filing a number of exhibits that included the names of potential witnesses. It included, grand jury transcript testimony, another of other materials that the special counsel's office wanted to either redact or keep sealed. And so there was some ongoing litigation about that. And Judge Cannon ultimately decided, no, the special counsel has not shown, a particularized kind of showing of why these things should remain redacted or sealed. And so she ordered the unsealing of those materials, but before they were actually unsealed, so they haven't been unsealed yet, the special counsel's office moved for reconsideration of that order. Among other things, there was some argument about the standard that Judge Cannon applied. And then there's also argument about, for example, the threats to witnesses and the need to kind of protect sensitive information about ongoing investigations, that sort of thing. And in the meantime—
Wait. Two key questions.
Oh, okay.
Two key questions.
Okay.
First, was there any discussion or mention of Roger's excellent article on exactly this subject in Lawfare?
Unfortunately, there was not.
Bastards. Second question. Was there any resolution to this issue?
There was no resolution to this issue.
So we really, in true Judge Cannon fashion, argued about a bunch of things and decided nothing. Is that an
Yes.
unfair characterization?
That is that's exactly what happened, Ben.
Well, that's a long day to get nothing. Did she give any indication? I mean, I'm going to give you a preview of what Judge Boy Wonder, Judge McAfee did today. He announced at the end of the day that there was a lot of material on the table about which he was not wrong, both factually and legally, and he would have a resolution of it in 2 weeks. Did Judge Cannon do anything similar, like tell us when we should expect a trial date, ruling on a motion to reconsider, or a resolution of any of this stuff?
Well, let me take it one by one. So on the trial date, she, if everyone recalls, the special counsel's office had asked for an early July date. And Trump's team had a kind of weird proposal where they said, we really don't need to go to trial on this before the election. It should be pushed out past the election. But if you really want us to give you a date, then you should set it for August. And so Judge Cannon had the parties explain those different arguments for their proposed dates. She told the special counsel's office that she thought that their July date was unrealistic. And then, Trump's August date, she didn't really show her hand on whether she'd be willing to put it out past the election. But she did ask, some pointed questions about the DOJ's position, for example, on whether and how soon they could have a trial close to the November 2024 election. And this was one of the kind of more interesting moments, is that DOJ has this policy that applies to investigations that they're doing. It's known as the 60-day rule or the 60-day policy. And basically anyone who's, running for office or a political candidate, DOJ says in its policy, which is not a law, it's a just internal policy within DOJ, that they try to avoid overt investigative steps within 60 days of that election. There's been some question, although
right. And just to be clear, for those who don't know the term overt investigative steps, this refers to things like executions of search warrants or indictments, things that the grand jury in its investigative capacity does by way of in public. So it doesn't generally include things like subpoenas but it's generally not a rule about trials, right?
Right. And so, and that's kind of been the common sense. I mean, it seems like it's not a rule that applies to charged conduct, but it hasn't been something that the special counsel's office has taken an explicit position on in court before any of these judges. And Judge Cannon, as this discussion about the trial date was going on, she specifically asked Jay Bratt for the special counsel's office about their position on this policy. And for the first time, he explicitly said, on the record in court, that they consulted with the public integrity section of the Justice Department, and the opinion that was given to them by the public integrity section is that the policy, the 60-day rule, does not apply to already charged conduct. So it would not apply to Trump in terms of in any way preventing the Justice Department from seeking a trial date that is within 60 days of the November 2024 election. So that was a very interesting moment because it's just kind of been a little bit unclear how that policy might apply or kind of guide the conduct of Jack Smith when he's seeking trial dates. And then the other very interesting moment within this trial date discussion is, as I said, Trump took a kind of tried to have his cake and eat it too position when it came to proposing trial date. He said, we don't want to go to trial before the election, but if you're going to set a date, set it for August, please. And Jay Bratt specifically argued that to Judge Cannon that, saying that they couldn't go to trial, but then giving her the August date was a way of basically blocking the DC trial from going ahead if Judge Chutkan gets the go ahead from the Supreme Court, pending this immunity ruling that's at SCOTUS right now. Basically, he said these are fake dates that they've provided you, Judge Cannon. They were made in bad faith. They're telling you that they can't go to trial. What they really want is an adjournment, but they want you to set the August date so that it could stand in the way of the DC trial going ahead. And that was a really, pointed moment. Judge Cannon, though, didn't really, she did not seem to focus a whole lot on the arguments from Trump about, the need to not be in trial near the election. She really just wanted to focus on how realistic either of the schedules were. So I would say that she's definitely not going to set it in July, but I just am not entirely sure when she will set it. And so we didn't get a resolution on that.
Roger, your witness.
Who did most of the talking for the government? Was it Jay Bratt or?
They split it up. So Jay Bratt did most of the scheduling argument for the government, and then David Harbach did most of the kind of legal arguments and it was kind of difficult to keep those apart at times. So, for example, the second issue that I mentioned, it was about this motion to compel and whether to expand the scope of the prosecution team. And it was a bit awkward for the government because Jay Bratt was there to basically just talk about the scheduling and how, if she did want a hearing on that, when they would, when the government would be available to do it, and what the procedure would be. But Harbach was the one who was kind of arguing the law around, like, what does a prosecution team actually mean under how it's been defined by various courts. So they kind of had a little bit of back and forth of one person would go up and one person would come back on that. But it was, those two folks, Harbach and Bratt, have been doing most of the argument throughout this case. But Jack Smith, at one point, when Judge Cannon mentioned the publishing the witness list, he did kind of look like he was ready to jump up out of his chair and say something.
Yeah. Now, with respect to scheduling, Trump and de Oliveira said they wanted to go August 12th if they had to go at all before the election. And then Nauta said something like he wanted to go in September. And he said, my attorneys are going to be unavailable for most of August. So how did that work?
Yes, and that was a point of contention from prosecutors. They were not very kind to say, because as I understand it, part of the reason why Nauta would want to go to trial in September relates to a planned vacation of his counsel, Stanley Woodward. And so prosecutors were very, again, not too thrilled with the idea that, a trial would be postponed because of Stanley Woodward's family vacation plans. And Stanley Woodward went up there and said, Your Honor, we're all human. And
hey, man, Stanley Woodward has every single defendant in every single case. You got to organize your trial schedule around his vacation plans, because how would, the guy's got to take a break sometime.
Certainly no one's earned a vacation more than Stanley Woodward.
Yeah, I mean, well, and this relates to, I'll get to that in a second, because that actually reminds me of an interesting moment in the hearing. But yes, so Stanley Woodward said, Your Honor, we're all human. I have 4 kids. I had this planned vacation for a long time. And Judge Cannon was very sympathetic to that. She said, I of course understand that when scheduling things, there's a human element to it. But to the point of Stanley Woodward representing everyone, or seemingly representing everyone in the Trump universe, there was another interesting moment in which they were talking about this discovery issue and how they felt the defense team feels that the prosecution has not turned over to them everything that they ought to have. One subject to that point were these materials that relate to DC grand jury proceedings. Of course, Stanley Woodward had represented a number of witnesses that appeared before the DC grand jury, both in the classified documents and January 6th case. And at one point he was saying to Judge Cannon, I know that there are things that they haven't turned over to us. And I know that because I represented a bunch of witnesses before that grand jury, but I can't even talk to my client about it because it's all, I'm still under seal for, some of those grand jury proceedings. So it was very interesting because it just kind of shows the nature. And of course, there's already been, a hearing around and issues that were related to potential conflicts that arose with some of the representation, because these are folks who have represented a number of Trump world figures. But it was kind of interesting because Stanley Woodward has represented so many folks in these proceedings. But that just was raised today.
All right. Before we shift gears to Fulton County, because it is now the bottom of the hour, which is the part where I hand off the ceremonial hosting baton to Anna, and Roger and I magically turn into guests. Roger, do you have any other quick questions about today's events?
Did she give any inkling about what she was going to do about this? Because I think this is a big deal if she's going to unseal these witnesses' names. I don't mean the whole list, which apparently she wants to do also, but the documents, this motion to reconsider about the documents attached to the motions to compel. Did she tip her hand there?
Well, Roger, she expressed some real skepticism about the idea that, she had clearly erred in originally ordering the unsealing. There was a lot of discussion. There was, the media interveners also had argument time as well. There was a lot of discussion about which standard should apply. Should it be this lower good cause standard? Should it be a kind of heightened First Amendment protection standard? And there was also discussion about, the differences between when you file a motion for discovery and the kind of different standards that apply to discovery materials in pretrial proceedings, like the motion to compel versus, other types of motions that are more substantive in nature. So she was really kind of grappling with all of that. She seemed to think that a lot of the case law that DOJ was citing, cases like Chicago Tribune, she mentioned that's a civil case and this is a criminal proceeding. And so she was trying to draw some distinctions there. Seemed like she really was not buying DOJ's argument arguments that on the whole, would have maybe left her with the impression that she had decided wrongly. She just didn't think that she did. On the witnesses issue, though, in particular, she seemed to be the most willing to maybe make some concessions on that. She mentioned at one point potentially having like a legend in which, like, for filings, they would redact out and substitute like fake names for people or something like that, which sounded very complicated. At another point, though, she also said something like, I feel like you guys, she said something like, you haven't shown a particularized need to protect witnesses, because has there been any witness that has actually come forward and said, I feel threatened or I've received threats, which was kind of shocking because she herself has received threats. She knows that judges in these other cases have received threats. It just seems very obvious that this is a concern. And she kind of later came around to that idea, that in a high profile case, you would be concerned. But then at the same time, she was saying, but you can't protect everyone from the internet. So it was all very kind of, it was unclear to me exactly where she came down on the specific witnesses issue. But if I had to say to the other materials, some of the exhibits that were grand jury transcripts or that kind of thing, I don't think she'd be inclined to reverse her order that she originally made.
All right, let's shift gears. If we got in a car from where Anna was today and we drove 551 miles northeast to, we would get to Atlanta and the Fulton County Courthouse, where a camera was filming and live streaming the events in Fulton County today. And Roger and I were watching, as I suspect were some of you. There was a really interesting day. So Anna, you are, for the last 30 minutes of today's live stream, the host. Roger and I are the guests. The floor is yours.
Yeah, this is exciting for me because usually I'm the Fulton County person on Lawfare. And so we've got a little bit of a switch here. And so I'm excited to hear about it. I have no idea what happened. I listened to like 2 minutes of argument after Judge Cannon's hearings were done. But why don't you start us off by telling, what happened and what were the arguments that were made?
All right. So, wow, that's actually a complicated question. So the what happened question is easy. Judge McAfee gave each side 90 minutes to make arguments on whatever points they wanted. And he allowed, this is only relevant to the defense, of which there are, there are like a dozen different legal teams, but he allowed them to divide up time however they saw fit. Mr. Abate did the entirety of the argument for the state. Let me summarize the argument as follows. The defense made the argument that, first of all, the standard of review is an appearance of impropriety, not an actual conflict. Number two, that the appearance that there is an actual conflict. In fact, Steve Sadow, several of the defense lawyers made the argument that there are several actual conflicts arising out of this fact pattern. Number three, that the fact pattern shows that Fani Willis and Nathan Wade were lying on the stand and committed fraud on the court. Number four, that the conflict involved a self-enrichment scheme in which the affair between them began earlier than either of them acknowledged, and that Therefore, they should be, at a minimum, there is an appearance of misconduct. And by the way, these issues about forensic misconduct concerning her speeches were revived in this argument. And so that she, A, had a self-enrichment scheme, B, played the race card in this church speech, and C, thus, and lied on the stand, such that there is both an actual and an appearance of conflict, and she should be disqualified. And as a very, very secondary matter, since they know they're not going to win on this point, the case should be dismissed. That is a very high altitude summary of the defense argument. The prosecution argument goes something like this. And I want to say Mr. Abate, who actually I think made a pretty good argument altogether, has a absolutely terrible delivery. And so you actually had to watch the whole argument before you saw that as an aggregate, it was kind of effective. Any 5 minutes of it were insufferable to listen to. And yet the whole thing was like kind of worked in some ways. Okay, so his argument is screw the appearance of conflict of interest or appearance of impropriety standard. The standard is an actual conflict of interest that can't be speculative, has to be financial in nature, and has to be based on the outcome of the litigation, not some stuff along the way, not an incentive, but you have to have a rooting interest in the side that you are in conviction for this to be a real problem. Number two, that all of the witnesses who are testifying, all by which I mean both of the witnesses who are testifying against Fani Willis, are disgruntled bad actors, disgruntled in different ways. But one is somebody she fired and who engaged in misconduct in the office. The other is a sexual assault former partner of Nathan Wade, who attacked a woman and was fired as a result of that and is out for revenge. And the cell phone data that appears to show them in similar locations and in repeated contact is unreliable. They are trying to put on a witness who is not qualified to evaluate it, and in any event shows some things, if you look at the totality of it, that are inconsistent with the defense's arguments, particularly that he was in the neighborhood of her apartment about as often before she moved into it as he was after, which gives rise to, and some of the listeners will appreciate this reference, gives rise to the Portia experience thesis and maybe the airport thesis. But he was there 10 times in the months before she moved into this apartment, and then 30 times in the months after. There's much more of the year that takes place after. Bottom line, and there's no reason to disbelieve her highly corroborated claims about cash repayments, the result being that there is no actual conflict of interest, and he should dismiss, boy wonder, Judge McAfee should dismiss the motion. That is the best brief summary that I can give of 3 hours of oral argument.
Right. And before we get to what you both thought about these arguments and where you come down on whether, Fani Willis will maybe be disqualified, There was also these outstanding evidentiary questions about whether the cell phone records you mentioned actually would be admitted into evidence and whether there might be further testimony on those. There was also this affidavit that the state wanted to get into evidence about this guy who said Fonnie Willis paid in cash at a winery. So what happened with that, just so that we have a clearer understanding of what is in and not in evidence?
Yeah, so he allowed proffers of all of the material that is not obviously in evidence, and he allowed argument based on the proffer, sort of, with the caveat that, hey, this is contingent on eventual admissibility, and he gave both sides a chance to talk about the material that they wanted to admit, with the caveat that the defense had 2 additional witnesses that they wanted to bring on for rebuttal and impeachment purposes that they'd only found out about today. And he basically said, we're gonna cut it off to stuff that you've given notice of within a reasonable period of time. So basically the cell phone data gets discussed on a tentative basis. The winery receipt guy gets discussed on a tentative basis. Everything kind of gets discussed, but it's not clear what's coming in or what's not. And just to round it out, at the end of the day, Judge McAfee said there are significant legal issues here, presumably meaning what the standard is, and there are significant evidentiary matters that he has to rule on, and he hopes to do it in a couple of weeks.
All right. Well, so putting aside for the moment what we think Judge McAfee might do, Roger and Ben, what did both of you think about these arguments? Let's start with Roger.
And just before we do, I just want to say Roger and I have not consulted about this at all. So this is the first impression I will get of Roger's reaction to this hearing and vice versa.
Well, the Abate, as Ben mentioned, I don't think he made McAfee's job easier, and especially with respect to the law. I think McAfee was, at times, he was concerned that there was a lot of law saying that the appearance of conflict might be sufficient. And the responses to that were, were not clear and not convincing. Some were painful, I thought. The judge at one point mentioned one of these opinions, and he said, he seems to rule on the basis of appearance. Why do you think that's dicta? It seems central to the holding. And Abate responded, I don't disagree, but an actual conflict was also found. And the judge said, they didn't find that. And then Abate said, that's my reading. An actual conflict was found. And he didn't go into it. He didn't explain further. So I thought there were some, that was not very helpful. On the facts, you know, there was sort of a very diffuse. I was surprised how important a role the church speech ended up taking. So there were a lot of different sort of discrete arguments about wrongdoing, and it began to have sort of a spaghetti on the wall feel to it. So there's 2 ways you can react. You can react, they don't really have anything, so they're throwing everything at the wall. Or you can say, you know, cumulatively, it all goes over the edge. McDougald had like 6 different arguments like that. Overall, what I really, McDougald representing Jeff Clark, but there's my overwhelming feeling is that I don't like the way the prosecutors have handled this. And they take, there is a, their arguments sound like, the summation of a criminal defendant who only has a reasonable doubt case. It's a slam dunk case. And so he's arguing all of these super technical things. You haven't shown the interstate commerce part of it, or, something like that. And then one of them mentioned, I think McDougald, when Willis resisted the subpoena in the divorce case, and she sort of threatened the divorce lawyer with obstruction. She wanted to, that's a really outrageous thing. And they came in and anyway, it all doesn't smell good. And I think it's a really, really tough call for McAfee.
So
Ben, how about you?
So I agree with that almost in its entirety. A few nuances. So first of all, let's take the remedies in declining order of plausibility. The defendants have asked for dismissal of the case. None of this just remotely justifies dismissal of the case. And they seem to acknowledge that by arguing the point only once and only in a single sentence. It's the last sentence of the entire defense argument. The case should and the case should be dismissed. And it reminded me a little bit of, and Carthage must be destroyed, just sort of stuck on. That is not going to happen. The second question is disqualification. And I very much agree with Roger that no component of this adds up to disqualification. The question is whether the cumulative spaghetti on the wall adds up to disqualification. And I do think the defense group made a very good argument. Whether it's an ultimately persuasive argument, I don't know. I thought there was a lot of good defense lawyering today, and they made the best case you can make out of this, that cumulatively, and they gave McAfee a lot of, I thought the one defense lawyer who made an argument for 6 separate actual conflicts of interest was one of the most effective 5 or 10 minutes of the day. And he's going to have to work on this one. So the third, I think you have to be pretty deep in the head of Scott McAfee to suss out how he's going to weigh and which evidence he's going to credit and which evidence he's going to not credit in order to figure out how he's going to handle that. And I actually don't want to predict it. I will say that if I were the judge in this case, I would not disqualify Fani Willis. I might very well disqualify Nathan Wade, but I would refer both of them to the state bar on the question of candor before the tribunal. And I do think the evidence that both of them have been less than truthful with the court in their testimony is unnervingly strong. And I don't know if it is the preponderance of I don't know how you'd think about that, because that's actually not what's before the court. But I am troubled by it, and I don't think prosecutors should behave that way, and I don't like it, and I have a very strong Roger-like reaction to that. Now, lying to the court is a crime, and it is a disciplinary offense for this as a member of the state bar. It is not actually a basis for disqualification unless you believe this theory that the appearance standard is the right one, which I think they are unpersuasive on. And so my instinct, if I were Scott McAfee, in which case I'd be a lot younger than I am, would be to deny the motion, but refer the questions of candor to the tribunal, to the bar. That's my sense of the right answer, but I could totally see being him and weighing the evidence differently than I do, but in a fashion that's perfectly plausible, where you say, okay, no one of these is an actual conflict of interest, but add them all up and you've got something real here, and she can't handle this case credibly, especially given the fact that she has been, that there's real questions about her candor to the court, and so I'm going to disqualify her. I don't think that would be a lawless or reckless decision on his part.
He did actually, oh, I'm sorry. You're muted. Oh, okay.
No, go ahead.
He did actually, and he said a couple of things that were explicitly along the lines of what Ben said. And he asked at one point, one of the defense lawyers, so when a lawyer isn't candid with the court, does the court police that himself, or do I send them down the road to the bar? And and so it sounded like he was thinking of trying to get out of this that way. That I might make a referral. The other thing he said was interesting is that what's the limiting principle? I mean, if she was dishonest, I mean, she signs every indictment. Is every indictment invalid? So, he doesn't want to, there's a consequentialist problem here. So, so for both of those reasons, I think Ben's suggestion might be where he's headed, but I really don't think it's decided.
So, yeah. And so, Ben, was there anything else that stood out to you about the kinds of questions that Mac, I know you say you don't want to predict what he's going to do, but one thing I'm curious about as someone who hasn't watched it is just, were there any telltale signs about the kinds of questions that he was asking other than what Roger just pointed out?
So he was really careful on the evidence side not to tip his hand. He did seem, as Roger pointed out, very interested in the cases in which courts had alluded to the appearance standard, and he had this very interesting colloquy with Mr. Abate about whether those cases are all that reference the appearance are all really actual conflict of interest cases, or whether there is any case that is purely a, hey, we don't find an actual conflict, but the appearance here really sucks, so we're disqualifying you. He pushed Abate on that. Abate, as Roger said, was a little bit squirrely on the subject and didn't really make an argument for what he described as his kind of conclusion about this one case. He did also, as Roger said, seem to say, hey, normally when something doesn't arise to a conflict, but there may be misconduct, we send it down the street to the state bar. He did seem a little bit attracted to that idea. And he seemed I would say in the way that a Fulton County former prosecutor is kind of wise to the ways of defense lawyers, seemed like pretty savvy about where the defense was, given an inch and taking a mile, kind of, so I came away from this hearing very much trusting him to make a wholly good faith judgment that may reflect my own admiration for the way he's conducted himself throughout these proceedings, and may reflect my sort of pro-McAfee bias. But I think he was again exemplary in his fairness and seriousness. He seemed to engage everybody. There were no theatrics to it. But boy, is he hard to read.
Yeah, he is hard to read, and he's always I should say, I don't think that should make people nervous one way or another, because he's always kind of been like that. He's not a judge who really wears, his cards on his sleeve. But so one thing that I'm curious before we wrap up is just, what if Fani Willis is disqualified? And we don't have to go into I can talk on Trump trials about kind of the practical consequences of that. But I'm just curious, Ben and Roger, how does that impact the larger accountability for January 6th and the 2020 election? What do you think the kind of wider impact would be on the disqualification, and kind of how this motion has impacted the other federal cases maybe, and the perception that the public has about it?
Well, I don't think it affects the federal cases, but if this case goes away, the federal case in Florida, I think, is in real trouble if this judge continues to handle it. In fact, I wanted to ask you almost if you thought, because I was a little surprised when I thought Trump would just take the position it can't be done before the election. But instead, he suggests throughout this August 12th date. Obviously, if he has to go to trial on something, he would rather go to trial before a Florida jury with Judge Cannon presiding. And in fact, I almost wonder if the special counsel themselves would rather this case were put off if there's an opportunity to get to wedge the DC case in there. I mean, did you get a sense of I'm changing the question around, but how serious was the August 12th trial date proposal?
I mean, Roger, they were very much, their first argument was that the August date was not possible, but they had to say a date. If Judge Cannon was set on setting a date, they wanted it to be August. I know that it sounds a little bit crazy, because on one hand, the special counsel's office saying that the August date is a fake date while they are only setting a date or proposing a date for a month earlier does sound like a little bit strange, right? But at the same time, you have to take that in context of what Trump's team was arguing to Judge Cannon, which was, we can't possibly go to trial at any time soon before the election. But if you're going to set a date, you should set it in August. They're planting the seed, I think, for, wanting to have a second continuance after the August date later on, expecting that, all of this stuff is going to drag out because of the CFO litigation and because of various other things. Judge Cannon was very, she kept talking about how there were 20 pending motions before the court, and she just had so much to do. And
she should try editing Lawfare.
I
20 pending motions doesn't sound like that big a deal to me.
No, and she made a really big deal out of having 5 motions that related to redactions or sealings, but it was because of the way that she has treated the, request or motions for sealing. And so it just, but in her defense, I will say she did seem a little bit warmer to DOJ than she has in the past. She was asking some questions of them to try to learn more information about how SEPA and classified information works. She had a little bit of a better rapport with them. She's been like totally stone cold icy when I've seen her interact with them previously. So this was the first time that I saw her feeling a little bit more, friendly towards at least David Harbach. I'm not sure she was very friendly towards Jay Pratt, but I will say, Roger, to answer your question, I really don't think the August date is a real date. I think that actually Jay Brad is pretty spot on, that it seems like having a placeholder August date in the classified documents case is pretty convenient if Judge Chutkan does get the mandate and is able to, then set a trial date for the DC case.
Well, I'm sorry, Ben, you want to?
No, go ahead.
We should wrap up soon, but to answer your question, I'm beginning to see, unfortunately, a pathway by which Trump could evade all responsibility. And if the Georgia case drops out, the Florida case is not going before the election. The DC case may not go before the election. The New York case, he can possibly get an acquittal because it's a strange case. And if he becomes president, there's lots of levers with which to abuse executive power, which nobody is going to hold him accountable for. So there is a pathway, I'm afraid, to evade all responsibility, and I'm quite concerned about it.
Well, yeah,
on that cheerful, uplifting note.
Can I say one more thing before we end?
But you also have to show your shirt.
Because it says Bo Taylor's boyfriend. It's I think too that it's not just accountability for Trump, right? Because keep in mind that the Georgia case is the only case that has all the co-conspirators or alleged co-conspirators who are also indicted. And I will also mention that I spoke to John Eastman at an event a few weeks ago. He's one of the unindicted or unnamed co-conspirators in Trump's DC indictment, which he has, publicly said. But I asked him about the, DC grand jury that was ongoing in that investigation. He told me that his understanding is that grand jury has expired. And so it seems to me that, and I have not seen any reporting or heard anything about that grand jury activity continuing. So it seems that those co-conspirators are maybe no longer under active investigation, though we don't know. But if the Georgia case, goes away because of disqualification of Fani Willis, it may just be that all these co-conspirators are never indicted or face any type of accountability.
Yeah, I think that's a critical point, that there is a group of people for whom Georgia is the accountability mechanism because the federal government decided not to indict, or appears to have decided not to indict, the unindicted co-conspirators. And that almost more than the Trump accountability function is one of the critical roles that Georgia case was going to play. So as not to leave you all in a total funk, I will remind you that by the end of this month, the New York case we are now March 1st. and we are less than a month from the opening of the first actual criminal trial against former President Donald Trump. So if you are rooting for a conviction of the president, former president, and as a 501c3 nonprofit, I am certainly not a rooter in this department. But if you are, your first chance comes this month as the New York case goes to trial, and we will of course be there. And if you like this format of kind of daily YouTube updates, some of which may be podcasts, some of which may not be podcasts, we'll be doing a lot of these as the different cases without cameras in the courtroom start going to trial. We are going to leave it there, folks. We're already 9 minutes over, and Lawfare Live we like to begin on time and end on time. So we're 1 for 2 today. From the Scott studio in Washington, D.C., thank you, Roger Parloff. From the Fort Pierce hotel room of her palatial mansion, thank you, Anna Bauer. And from the hammock studio in the guinea pig shirt,